Okay, let's dive right in. We are absolutely surrounded by contracts. They're like this invisible legal architecture that's hiding in plain sight, and they govern so many of the little interactions we have every single day. So today, we're going to pull back the curtain on the fundamental rules that turn a simple promise into something the law will actually enforce.
I mean, just think about it for a second. That coffee you bought this morning, that's a contract. Clicking that I agree button on some new app, the one nobody ever reads, that is absolutely a contract. And signing a job offer, well, that's a huge one. These aren't just simple transactions. They are legally significant moments, and they're all built on promises.
And that really brings us to the central mystery we are solving today. What's the secret sauce? What's the magic ingredient? At what exact point does a casual, "yeah, I promise," cross the line and become something you could actually be taken to court over? That is exactly what we are about to break down.
So here's our game plan. First, we're going to define what a binding promise even is. Then we'll figure out which legal rulebook we need to use, because it's not always the same one. From there, we'll get into the two essential ingredients, offer and acceptance, before we uncover that final crucial piece, what I like to call the seal of seriousness that makes the whole thing stick.
All right, so let's start with the big picture. All of contract law, really, it all just boils down to this one powerful idea. Some promises matter so much that our legal system will step in to make darn sure they're kept. It's the mechanism that lets us, as a society, rely on commitments people make for the future.
Now check out that very specific language, bargained for exchange. This is so crucial. A contract isn't just an agreement, right? It is a deliberate trade where both sides are giving something up to get something in return. It has to be a two-way street.
Okay, so if the law is going to enforce these bargains, where do the actual rules come from? Well, it's not just one giant book. You have to know which rule book applies to your specific situation, and there are two main ones to choose from.
And this is the first big fork in the road you'll come to. On one side, you've got common law. This is the law that's built up over centuries from court decisions, and it governs things like services or real estate. On the other side, you've got the Uniform Commercial Code, or the UCC. That's a very specific set of statutes for contracts involving the sale of goods, any tangible, movable item.
And this is why, before you can analyze any agreement, this is the first question you absolutely have to ask. Are we dealing with goods, like a car or a boat? If the answer is yes, you're in the world of the UCC. But if we're talking about services, like hiring a painter or a web developer, then you're in the world of common law. Getting this right is step one, and it changes everything.
All right, so once we've picked our rulebook, we need to look for the core components. I want you to think of it like a blueprint. It doesn't matter how big or complex the deal is, every single valid contract is built from the exact same two essential ingredients.
And here they are. First, you've got to have mutual assent. This is the agreement part. It's the evidence that both parties were totally on the same page. You'll often hear lawyers call this a meeting of the minds. And second, you need consideration. This is the exchange part, the proof that this was a real bargain and not just a one-sided gift.
So how do courts know if you actually had a meeting of the minds? Well, they can't read your secret thoughts. Instead, they use something called the objective theory. What matters isn't what you were secretly thinking or intending. What matters is what your words and your actions would lead a totally reasonable person to believe. So if you click I agree, the law objectively sees that as agreement, whether you read the fine print or not.
So let's really break down that first ingredient, mutual assent. How do the courts find this meeting of the minds? It's not some vague feeling. Nope. It's a very specific process with two distinct steps. There has to be a valid offer and then a clear acceptance of that offer.
An offer is way more than just a suggestion. Legally, it's a clear signal that you are ready to be bound by your promise, like right now. It has to have definite terms, and this is the most important part, it gives the other person the power to seal the deal just by saying yes.
But an offer doesn't last forever. It definitely has a shelf life. The person who made it can just take it back. That's revocation. Or the other person can just say no, rejecting it. Sometimes it just expires because too much time has passed. Oh, and a counteroffer? That is one of the most common ways to kill an original offer instantly.
Under common law, this is called the mirror image rule. It means your acceptance has to perfectly mirror the offer. The classic case for this is a lawsuit called Normile versus Miller. So let's say I offer to sell you my car for $10,000, and you say, "Great, I'll take it for $9,000.
You haven't accepted, you've just rejected my offer and made a brand new one. My original offer is dead and gone.
Now, there are special situations where an offer becomes locked in, where it can't be revoked. For example, in an option contract, you've literally paid money just to keep the offer on the table. Under the UCC, there's something called a firm offer. And if someone has already started doing the work you asked for in a one-sided deal, you can't just pull the rug out from under them.
Okay, so let's say we have it. We've got our mutual assent, a valid offer, and a valid acceptance. We are still missing our second and final ingredient, consideration. This is the thing that separates a legally binding contract from just an empty, unenforceable promise. It really is the proof of seriousness.
And there's that phrase again, bargained for exchange. Consideration is the what of the bargain. Each side has to give up something of legal value. They have to incur what's called a legal detriment. And that can be money, property, a service, or even giving up the right to do something.
A really great way to remember this is what some law professors call the Beyoncé rule. It's not a real contract unless both sides liked it enough to, well, put a ring on it. A simple promise to give someone a gift for nothing in return, that lacks consideration. Both parties have to give and get something of value.
And that something of legal value doesn't have to be money at all. The classic case of Hammer v. Sidway proves this perfectly. In that case, an uncle promised his nephew $5,000 if he didn't drink, smoke, or gamble until he turned 21. The court said, hey, giving up his legal right to do those things was a valid detriment, and that was enough to count as consideration. The promise was enforceable.
So let's pull all this together into a practical toolkit. From now on, when you look at any potential agreement, you can ask these questions. First, is it for goods or services? That tells us if we use the UCC or common law. Next, is there a clear offer and a matching acceptance? Then, is there a bargain for exchange of value? And finally, was everything measured by what a reasonable person would understand?
When you get right down to it, this is the entire philosophy of contract law in a nutshell. It's all about creating a predictable system where people can rely on commitments. But, and this is a big but, it only steps in when the evidence shows that both parties consciously and deliberately entered into a real bargain for exchange.
And that brings us to the final thought I want to leave you with. Now that you have the basic blueprint for a contract, offer, acceptance, and consideration, start looking for it. I promise you are going to be amazed at how often you see these fundamental building blocks shaping the world all around you.